All right, let's dive into a massive overhaul of corporate law that's on its way. We're talking about the Corporate Laws Amendment Bill of 2026, and it's poised to totally reshape the business world. So in this explainer, we're going to break down exactly what this landmark legislation means for companies, for directors, and really for the future of doing business in India. You know, at its heart, this huge bill is trying to do two things that sound like opposites. On one hand, it wants to slash red tape and make it way easier to run a business. But on the other hand, it wants to tighten the rules to make sure companies are managed responsibly and transparently. It's a really fascinating balancing act, and, well, the success of the whole law pretty much depends on getting it right. So, to really get our heads around this balancing act, here's how we're going to tackle it. We'll start with the big picture, the new blueprint itself. Then, we'll zoom in on how it makes business easier and how it strengthens governance. From there, we'll get into some brand new rules for directors and wrap up with a major philosophical shift, moving from felonies to fines. Okay, let's kick things off with Section 1, the new blueprint. So what exactly is this bill? Well, it was introduced in the Lok Sabha on March 23rd, 2026, and believe me, this isn't just a minor tweak. It's a major overhaul of the two laws that are basically the bedrock of India's corporate world, the Companies Act of 2013 and the LLP Act of 2008. And really, this is what it all boils down to. This is the why behind all these changes. It isn't about changing rules just for the sake of it. The whole point is to strike that crucial balance, to give businesses more freedom and flexibility to grow, while also demanding a much higher standard of accountability from their leaders. So let's look at the first side of that coin, making business easier. This whole section is focused on one key goal: helping companies, especially the smaller ones, thrive without getting buried under a mountain of paperwork. It's all about cutting down that compliance burden. Now, this number right here, it's an absolute game changer. 200 crore rupees. That's the new annual turnover limit to be called a small company. So why does this one number matter so much? Because it means thousands of businesses will suddenly fall under a simpler, less regulated framework, freeing up a ton of time and resources.
And it's not just that one big number either. There's a whole bunch of practical changes. Virtual annual meetings? Yeah, those are now officially allowed, which saves a huge amount of money. Need to call an urgent meeting? The notice period is slashed to just 7 days for faster decisions. And get this, for all those newly defined small companies, you're now only required to have one board meeting a year. Every single one of these changes means more flexibility and fewer headaches for business owners.
Okay, so we've talked about the simplicity side of things. Now let's flip the coin and look at the other goal, strengthening corporate governance. This is all about building more trust and transparency. The thinking here is pretty clear. If you give businesses more freedom, you also need stronger guardrails to protect investors, employees, and the public. A huge part of this is the new fit and proper criteria. And this is a major shift. See, it used to be that you could be a director as long as you weren't actively disqualified for something. But now, the tables have turned. You have to proactively prove you meet specific standards for integrity and competence before you can even be appointed. It's a much, much higher bar to clear. And here's another new rule, and you really can't get much clearer than this. Auditors cannot be consultants. This is designed to get rid of a massive potential conflict of interest. I mean, an auditor's independence is everything for a fair financial assessment, right? And that independence is totally compromised if they're also getting paid for other consulting work. And to give that rule some real teeth, the bill brings in a mandatory 3-year cooling-off period. An auditing firm has to wait a full 3 years after their term ends before they can offer any non-audit services to that same company. This creates a very clear, sharp line in the sand to maintain auditor independence. That brings us perfectly to our next point, the new rules for directors themselves. And these are all about cranking up the dial on personal accountability. The bill makes it crystal clear that having a seat in the boardroom comes with some very serious, non-negotiable responsibilities. So if you're a director, you can think of this as your new non-negotiable checklist. First, you have to periodically verify your director identification number, or DIN. It's not a one-and-done thing anymore. Second, if your DIN goes inactive, you are legally barred from acting as a director. And third, the big one, if you fail to file the required documents for 2 straight years, you're automatically disqualified. The message is pretty simple. Stay on top of your compliance or you're out. And this little detail shows you how the bill is systematically closing potential loopholes. There were already strict rules about loans to directors that applied to companies, but now those same rules are being extended to limited liability partnerships, or LLPs. This just makes sure the same high standards are applied across the board. All right, on to our final section, and it's a really important one. Fines, not felonies. This represents a fundamental change in philosophy. The whole idea is to decriminalize dozens of corporate law offenses. Instead of treating procedural mistakes like crimes, they'll be handled as civil matters with financial penalties. This frees up the criminal courts to focus on what they should be focusing on: outright fraud. This table really makes that shift clear. So, for example, if you default on holding your annual general meeting, that's now a 1 lakh rupee penalty plus a daily fine. A mistake in your prospectus, a 2 lakh rupee penalty. See the pattern? The consequences are now mainly financial, handled through a civil process, which is way faster and less of a burden on the whole system. This quote right here really sums up the entire idea perfectly. The aim is to punish the crime, not the mistake. So, all those procedural slip-ups and honest errors will be handled with fines, saving the heavy hammer of criminal law for serious offenses like fraud. So, after all of that, what are the 3 big things you need to remember? First, that expanded small company definition is huge. It means simpler rules for thousands of businesses. Second, stricter rules for directors and auditors are kicking off a whole new era of accountability. And third, decriminalization means for many slip-ups, the consequence is now a financial penalty, not a criminal court date. And that brings us to the final, crucial question. This bill is a really ambitious attempt to achieve 2 goals that are often in conflict: simplicity and accountability. But will this new blueprint actually succeed in reshaping the corporate landscape for the better? How this all plays out in the real world? Well, that's the story we'll all be watching. Thanks for joining this explainer.